name is Michael Lee. I represent Mr. Smart. So, for clarity, you were present during the interviews with all three individuals. Is that accurate?
Yes, sir.
Okay. And Mr. Barshaw and actually, Mr. Smart didn't claim ownership to any gun.
No, he did not.
He did not own any guns.
He did.
Mr. Barshaw and Mr. Barshaw, they both said some guns belonged to them.
Correct.
No further questions. Thank you.
Any further comment?
No, Your Honor.
Thank you, Ross.
Okay.
No, Your Honor.
Thank you, sir.
Thank you.
Any further documentary on this one?
No, Your Honor, just argument. I will rest at this point.
You may be heard.
Your Honor, the Commonwealth is asking you find the defendants dangerous and hold all three defendants without bail based on 58A. Your Honor, these defendants, the Commonwealth has proved their burden with regards to these defendants. They are all charged with a violation of Chapter 269, Section 10A. They clearly, sorry, Your Honor. We'd ask that the court find by clear and convincing evidence that personal recognizances will not reasonably assure the appearance of these defendants, and their release will certainly endanger the public. The Commonwealth basis for this is the evidence that you heard today, as well as on the previous date. The nature and circumstances of these offenses, you have the police report in evidence, as well as the officer's testimony, and the fact that their release would pose a danger to the community at large. Based on that, as well as the potential penalty that these defendants face, Your Honor, just to briefly go over the facts, these three defendants drove here from Tennessee in order to sell firearms in the city of Brockton. We have two defendants who admitted to that in an interview. They came here with a substantial amount of firearms in order to sell here in Brockton. They had 9 firearms in various locations inside that motor vehicle. There were several that were located in the trunk. You have photographs of the firearms that were specifically located inside the trunk. There were various firearms, including Glocks, as well as certain Glocks that had lasers on them, some that had mounted flashlights on them. There was also several magazines that were located. There was over 15 magazines, Your Honor, that were located inside that motor vehicle. Some of those were loaded, some of them were not loaded. Some of them, they had various capacity, including ones that had over the capability to hold over 30 rounds of ammunition inside of them. There was also an assault rifle that was located inside that same motor vehicle. It was located inside the trunk. And then we had over 541 rounds of ammunition. It was various types of ammunition, including hollow points, as well as rifle ammunition. Specifically with regards to hollow point ammunition, Your Honor, this is substantially deadly when it strikes a person. It is due to create a deadly situation in terms of tearing up internal organs. It's supposed to specifically mushroom out as soon as it hits something in order to cause the most amount of damage and to stop that bullet from continuing through. Based on all of that evidence, Your Honor, the fact that they drove here specifically from Tennessee to sell these firearms, and we have statements from them. I know that there's some disagreement between the co-defendants about which firearms were being sold, but the Commonwealth's position is that doesn't matter, that they were coming here specifically to sell firearms. The Commonwealth's also specifically concerned with regards to the passenger. Your Honor, he came up here with that Glock that was loaded with 31 rounds of ammunition. He made a statement to those officers that he was willing to use that if anything occurred. With that evidence, as well as the evidence that was located inside that motor vehicle that had the handkerchiefs, there's 2 red handkerchiefs. There was also 2 black face masks, as well as gloves. This situation could have been deadly, and these guns could have hit these streets, causing a serious safety concern for the community at large. I don't think there's any amount of bail that will hold them. The Commonwealth recognizes they have no record in Massachusetts. However, they also have no ties here. Considerably, their stories all changed. They said that they were coming up here to visit family, that they were stopping in New York. Notably, New York is before Boston. And then the story changes that they were going to leave Boston and then go back to Brockton One of the co-defendants, I believe, didn't even know he was in Massachusetts or in Boston specifically. However, they said that they were going to stop in New York. All of these facts are extremely concerning for the Commonwealth, Your Honor, and the fact that they specifically drove here from Tennessee in order to sell these firearms. It's up to the gun owners. I understand that they're from Tennessee. The gun laws are different down there. However, here, they were committing an illegal sale, Your Honor, and I expect, based on the fact that they were not truthful, that they continuously changed their story, that all three of them acknowledged, at least knowing that the guns were specifically in the car. I understand that defendant Smart did not own any of the firearms. However, he still drove here from Tennessee, knowing that many firearms were located inside the motor vehicle. I also understand that these three defendants don't have a out-of-state record, but they chose to drive approximately 15 to 20 hours in order to sell these firearms specifically. For those reasons, I don't think there's any sort of amount of bail that would reasonably assure their appearances, to return to the Commonwealth, to answer to the charges, and to assure the safety of the community at large.
Your Honor, Tina Green on behalf of Mr. Baskette here in the dock. Your Honor, you heard that my client has no record. He's 20 years old. He's from Tennessee. He's never left Tennessee before in his life. As the DA pointed out, the gun laws are much different in Tennessee, and I know that ignorance is not an excuse to break the laws of Massachusetts. But however, I do want to point out that he is charged with one gun. He's charged with possession of the firearm, the firearm that he stated was his personal firearm to the officer, carrying a firearm without an FID card, and possession of the ammunition that went with that firearm. Your Honor, he has no other record. He was forthcoming with the police, and none of these individuals, including my client, I specifically asked if he had given them any difficulty when they approached him. He immediately put his hands up. He was compliant. He's shown that he can be compliant. He can comply with whatever bail conditions that you release him with. I understand that the problem that they have no ties. My client has no ties to this community. However, if you were to go by that argument, that you would have to hold everybody that lives out of Massachusetts without bail because they might not come back. They could have been dangerous. He's in a passenger seat of a car. You have another individual that tells the ATF and the Brockton police that he owns the guns in the trunk, and that he alone was planning on selling those guns. My client is a passenger in the car. He's along for the ride. He's not charged with conspiracy to sell those guns. He's a passenger in the car. He's going up to Boston. He's leaving Tennessee for the first time, and then he's going to New York. They tell the police officers, and I don't know if that came along the other day, but they were going to rent an Airbnb in New York and then go back to Tennessee. There are these lesser restrictive means to carry this case out and have my client appear. He lives with his mother and his young siblings in Tennessee. He is the sole breadwinner in that family. His mom makes $700 a month and on stability. He works as a head cook at the Waffle House. He's had that job for approximately a year and a half in Tennessee, and he pays all of the utilities and the bills for the apartment that are not covered by the mother's disability payment of $700 a month. If he were to be held and not appear here, his family would lose their apartment. He tells me, I asked him how he would get here, and he said that he would drive here. I don't know, I want to suggest an electronic monitoring bracelet, but I don't know how that would work out of state. I didn't have the opportunity to meet with the probation department before this hearing. It is important to note that he has no prior record, Judge. He's 20 years old. He's still in high school. He has a difficulty reading, and he is still trying to get his high school diploma. Apparently, he's at a school which will allow him to do that on a note as well, he did tell them that he purchased this gun, and there was, the ATF agent and the officer did recover a bill of sale for that one gun in the car, Your Honor. So I'm asking that you release him with whatever conditions you see just. And he does promise to appear at the next date. Thank you.
Good afternoon, Your Honor. On behalf of Mr. Barshaw, the Commonwealth tells us that it moves for detention under 276 Section 58A because of the weapons, the number of weapons. The reality is, as we know, under 276 Section 58A, simple possession of the weapon is not an issue to hold a defendant on a dangerousness hearing. What makes it an opportunity for the Commonwealth to hold them on a dangerous hearing is because there is a weapon that has a large capacity and there's a feed with a large capacity feeding device for that weapon. That one weapon gives them or allows them to hold this dangerousness hearing. Otherwise, under Commonwealth versus Young, we know that simple possession is not sufficient to have a dangerous hearing. And also know that what they tell us is that this is really and truly a regulatory offense where it is a victimless crime. And yes, there were several handguns, several weapons that they should not have had in Massachusetts. But we are making a crime dangerous in Massachusetts, which is not even a crime from the state that they come from, which is Tennessee. In Tennessee, you don't need a license. You can buy firearms. You can carry them in your car. And that is not a crime, and that does not make you a dangerous person. But here in Massachusetts, the Commonwealth suggests that because you have these firearms in this car, that makes you a dangerous person. I suggest to the court that it does not. I suggest that the court go to Commonwealth versus Young, as well as Section 276-58A, which tells us specifically that the dangerousness hearing can only be held because of a large capacity feeding device with a large capacity weapon.
Which is present in this case.
It is, I am saying it is present in this case, yes, that's why we're here and they have. But it is not the assumption, oh, there's all these guns in the car. If it were just simple firearms, even 9mm firearms, that don't have large capacity feeding device with it, then we wouldn't be here. It's not a numbers game in terms of how many firearms we have. That does not make the crime a dangerous crime. It's still a regulatory offense crime. The Commonwealth says what could have happened, what may have happened, but the reality is that there is no evidence that these people met with anyone, contacted anyone, to say that there was going to be a sale. Did they make some incriminating statements that were not recorded to an ATF agent? Yes, Your Honor, they did, according to the reports that have been provided. However, on behalf of Mr. Barshaw, I would like to present the court with a letter from one of his aunts who is in Tennessee, with a letter of the employment agency in Tennessee who helps him acquire employment, and he was working at the time at a metal factory, Your Honor, where they clean out the scraps, they take the metal off from the cars, and that metal gets resold. And in addition, I want to advise the court that although he does not have any family here in Massachusetts who can afford him a home, there is family in Connecticut, and I do have their names and their addresses, which are his aunts and some of his cousins, that are willing to have him in Connecticut during the pendency of this case. And of course, his family in Tennessee is ready, willing, and able to come and pick him up. And I understand that this is a serious offense, but there are less restrictive alternatives that this court can impose, short of holding them without any bail whatsoever. I suggest to the court that a bail can be set in an amount that would be affordable to the family to make, and that their children, and I call him child because he is only 18 years of age, will be brought back here to make any appearances, whether he gets to reside in Connecticut or he gets to reside back home in Tennessee. May I approach, Your Honor?